Good morning, ladies and gentlemen. I'd like to welcome you to County Court at Law number 2. My name is Judge Terrence L. Holmes. I'm the presiding judge here in County Court at Law number 2, Jefferson County, Texas. This morning, we have our arraignment docket. And what the arraignment is, it's an opportunity for the court to tell you what you've been charged with, what your rights are, and the options that you have concerning your case. The case that you have in this court is a misdemeanor case. Cases are classified, criminal cases are classified as either felonies or misdemeanors. Your felony type cases are the ones that are what we call most serious type cases. They are held in district court. The misdemeanor cases are what we normally, they refer to them as petty offense. It doesn't mean that they're not serious, but the difference between the two is the range of punishment. For a felony case, your punishment can entail being sent to the state penitentiary, which is Texas Department of Corrections. For a misdemeanor case, your punishment you cannot be sent to the state penitentiary. However, your punishment can entail confinement in the Jefferson County Jail. Now, there are 3 types of misdemeanor offenses. There's a Class A, Class B, and Class C. Your Class C offenses are fine only. You cannot be sent to the county jail on a Class C offense. And your Class C offense is normally like your traffic tickets and cases that are normally in the Justice Court, which is the JP Court, or the Municipal Court, which is the City Court. We handle, in this court, Class A and B misdemeanors. The difference between the Class A and B misdemeanors are is the range of punishment. For a Class A misdemeanor, which is the highest misdemeanor that we have, your punishment can be confinement in the county jail for a term that does not exceed 1 year or 365 days. Or it could be a fine that does not exceed $4,000. Or you could be given both such fine and confinement. Now, when I say that it does not exceed, it means it can start off at, for example, jail time will start off at 1 day all the way on up to 365 days or anywhere in between. A fine could start off at $1 and go up to $4,000 or anywhere in between. Or you could be given both such fine and confinement. For the Class B misdemeanor, the range of punishment is confinement in the county jail that does not exceed 180 days. So you can be given jail time from 1 day all the way on up to 180 days, anywhere in between. Your fine can be anywhere from $1 to $2,000. It cannot exceed $2,000 or anywhere in between, or you can be given both such fine and confinement. Now, you may qualify for probation. There are 2 types of probation. One type of probation is called deferred adjudicated probation or unadjudicated probation. The other type of probation is called adjudicated probation, or what we normally refer to it as regular probation. The difference between the two is with the deferred or the unadjudicated probation, it does not result in a conviction in your record. So if you successfully complete the probation, the case will be dismissed. You will not have a conviction on your record, and you may qualify for what is called a non-disclosure, which means we cannot tell the general public that you are on deferred adjudicated probation for this offense. However, if you violate your unadjudicated probation, the state can file a motion to revoke your probation. And if they file a motion to revoke your probation, and if your probation is revoked, you may get a conviction. If you get a conviction, obviously case is not going to be dismissed and you cannot get a non-disclosure. The other type of probation that I mentioned earlier is adjudicated probation or regular probation. With regular probation, it does result in a conviction on your record. However, if you successfully complete the regular probation, there is something that is called judicial clemency. What that means is the court can set aside your conviction. And the way that works is you have to first complete the probation. There cannot be any more time left on the probation. And then the court has to discharge you, which means to let you off of the probation. If those things happen, then the court can allow you to come back into court to take back or to withdraw your plea of either guilty or no contest. And any complaint, affidavit, or information that has been filed against you will be dismissed. And the court can set aside your conviction, which simply means you will no longer have a conviction. Now, however, if you get a subsequent or another conviction later on, then the court, then if you apply for a license, say like with CPS, they can deny giving you a license, or if you have a license, they can revoke or suspend that license that you have with CPS. If you are not a U.S. citizen on a plea of guilty or no contest, it may result in deportation, which means you can get put out of the country. Exclusion from admissions, which means that if you are outside the country trying to come in, they can prevent you from coming in. Or it can result in denial of naturalization, which means that if you have applied for citizenship, they could deny your application for citizenship. Now, as a defendant in a criminal case, you have three options. We passed out a clipboard with some forms on it. And on that clipboard, it states that you have, as a defendant, you have three options. Number one, you may hire an attorney. Number two, if you do not have enough money to hire an attorney, you may request an attorney to be appointed to represent you. Or number three, you may represent yourself. Now, if you want an attorney to represent you and you have enough money to hire an attorney, the case will be reset to give you time to do so. If you want an attorney and do not have the money to hire an attorney, you will need to fill out a financial questionnaire so that the proper person can determine whether or not to appoint an attorney to represent you. You may not speak to the prosecutor about your case unless you sign a written waiver of your right to be represented by an attorney. Be aware that there are dangers to self-representation. Waiving your right to an attorney and representing yourself may result in a worse outcome for you and your case, including the loss of significant legal rights and opportunities relating to military service, possession of a firearm, housing and public benefits, child custody, immigration status for non-citizens, and employment. If you choose to proceed without an attorney, you may change your mind at any time and may request counsel from the court. Now, at the bottom of the document, it states defendant's choice, mark initials next to only one choice. If your choice is, I want to reset this case to hire my own attorney, then you will put your initials on the first line to the left. If your choice is, I have already hired an attorney whose name is, then you'll put your initials on the second line to the left and the name of the attorney on the line to the right. If your choice is, I want to apply for court-appointed counsel, then you will put your initials on the third line to the left. If your choice is, I have a court-appointed attorney whose name is, then you'll put your initials on the fourth line to the left and the name of the attorney on the line to the right. If your choice is, I want to waive my right to an attorney, and represent myself, then you'll put your initials on the fifth line to the left. Now, once you have finished initialing one of the five lines, then you assign at the bottom where it says defendant, and you would date it today's date, March 16th of 2021. Now, for those who will be uh, applying for a court-appointed attorney, you would have to fill out a financial questionnaire that we'll fill out later. And those of you who will be representing yourself, you'd have to sign a written waiver, and the written waiver is the second page of that's on the clipboard. And I'll go over that. It says waiver of counsel for purposes of entering a guilty plea or proceeding to trial. I have been advised of the nature of the charges against me and the dangers and disadvantages of self-representation. My waiver is voluntarily and intelligently made. Furthermore, I have been advised this 16th day of March 2021 by the County Court at Law number 2 of my right to representation by counsel in the case pending against me. I have been further advised that if I am unable to afford counsel, one will be appointed for me free of charge. Understanding my right to have counsel appointed for me free of charge, if I am not financially able to employ counsel, I wish to waive that right and request the court to proceed with my case without an attorney being appointed for me. I hereby waive my right to counsel, and if that's your choice, then you will sign on the line that says defendant, and you will date it today's date, March 16th of 2021. Now, as a defendant in a criminal case, you have a right to have a trial by jury. And what a trial by jury is where the people who are sitting in that area, we call that the jury box. 6 citizens from Jefferson County will be selected on your case, and they will decide whether or not you're guilty or innocent after listening to all the evidence in the case. You also have a right to waive, which means to give up your right to have a trial by jury. And you will not have a trial by jury. You have a right to just have your case come before the judge. And either you can come before the judge with a trial before the judge, which we call a bench trial, or you can come before the court on a plea if you're pleading guilty or no contest. And there are 2 types of pleas. One type is called a agreed plea bargain agreement, where you make an agreement with the state or with the district attorney's office. The other type is called an unagreed plea bargain, where you do not have an agreement and you come before the court and you ask the court to assess punishment. You also have a right to have witnesses that come to court in your case. Witnesses, you sit in that area right there. We call that the jury box. And the witness will, they can testify for you or against you. And you can ask some questions. We call it either direct examination or cross-examination. Now, you also have a right to waive or give up your right to have witnesses to come to court. And by doing so, you will not be calling any witnesses on your behalf in your trial. You also have a right to see the evidence. We call that, you have a right to have discovery, to see the evidence that the state has against you. That is, you can see the videos, the witness statements, police reports, etc. Now, you also have a right, if you would like to see that evidence, then the state can allow you to have access to that evidence, you or your attorney, if you're represented by an attorney. Now, if you do not want to see the evidence, you could simply waive, which means to give up your right to see the evidence, and you would not see the evidence that the state has against you. You'll have an opportunity to speak to the prosecutor. If you're representing yourself, or if you have an attorney, your attorney will have an opportunity to talk to the prosecutor about your case to see if y'all can work out what is called a settlement. It's really a plea bargain agreement. If you are able to work out a plea bargain agreement, the court, the judge, does not have to follow that agreement. If the judge does not follow that agreement that you have worked out with the state, then you can withdraw or take back your plea. You don't have to go forward with your plea of either guilty or no contest. Now, if the judge does follow the plea bargain agreement, if you decide that you want to appeal, and what an appeal is, you would like to have a higher court to look at your case for them to determine whether or not you've been wrongfully convicted, or whether or not we've committed an error by convicting you, then you have to get the court's permission if you have a plea bargain agreement. Now, if you don't have a plea bargain agreement, then you don't have to get the court's permission. Okay. Now, there are, if your case does go up on appeal, and if it goes up on appeal, you go to an appeal court, the court give you permission, then your case will go to the Ninth Court of Appeals. It's right above us. Okay, right on the 3rd floor. They will review your case. They will decide whether or not you're wrongfully convicted or we committed an error by convicting you. If they can do one or two things. They could grant your appeal or they could deny your appeal. If they grant your appeal, then they could simply find you not guilty, or they could send the case back down to this court and order this court to give you a whole new trial. If they deny your appeal, then you can appeal it to a higher court than them. That higher court is called the Texas Court of Criminal Appeals. They're located in Austin, Texas. It is the highest criminal court in the state of Texas. You will have to file what is called a pro se petition for discretionary review. Now, if you file a pro se petition for discretionary review, that simply means that you will be filing it on your own without the assistance of a lawyer, and you'll be asking them to look at your case to decide whether or not your appeal should have been granted, see whether or not you've been wrongfully convicted, or to see whether or not this court has committed an error by convicting you. Now, they can do one or two things. They could grant your pro se petition, or they can deny your pro se petition. If they grant your pro se petition, then they could simply find you not guilty, or they could send the case back down to this court and order this court to give you a whole new trial. If they deny your petition, then at that point, your conviction will stand. Now, everyone that's here for arraignment, you have been arrested on your case. Every day that you spent in jail can be used as credit toward your punishment. So that just simply means that if, let's say you're able to work out a plea bargain with the state of Texas, let's say they're offering you 5 days, you spent 5 days in jail, that means that you won't have to do any more time in jail on your case, because you will be given credit for time served, the time that you've already served. Now, if you have some more days, then you would have to serve a little bit more time, all right, to complete the amount of time that you have on your case. The other thing is, if every day that you spent in jail, you'll get credit at $100 per day. So if you spend 5 days in jail, that's $500. If you're in the state, works out a plea bargain agreement, your fine and court cost is $500. You won't have to pay anything. Why? Because you spent 5 days in jail, that's $500. And so your fine and court costs will be taxed and retired. If you have a fine and cannot pay the fine that day, then we can put you on what is called a payment plan, which means you can pay it off on monthly installments. Or if you cannot pay it off at all, then we can convert your fine and court costs to community service. And every hour that you work on community service, you'll get $12.50 that will go toward your fine and court costs. So, an 8-hour day is basically $100. You work 8 hours on the community service, that's $100 that's gonna go toward your fine and court costs. Jefferson County has a program that is called pretrial diversion. Now, let me back up before I get to that. You have an option to either plead guilty, not guilty, or no contest. If you enter a plea of not guilty, you're telling the court that you did not commit the offense that you've been charged with. If you enter a plea of guilty, you're telling the court that you committed the offense that you've been charged with. Or if you enter a plea of no contest, you're telling the court that you will not be contesting or you will not be fighting those charges. Jefferson County has a program that is called pretrial diversion. Pretrial diversion is a program that if you are accepted in the program, your case is dismissed and you could get it expunged from your record. Expunged means it could be erased, wiped out, or deleted from your criminal record. So it's just like it's there and then it gets deleted, it's not there. And that with that program, in order to get into the program, you cannot have a criminal history. It has to be your first offense. You have to get an attorney to assist you to get in the program. And it cannot be an offense involving unlawful carrying a weapon or resisting arrest. And if you, as I said, if you get into the program, your case is dismissed, you complete the program, then you can qualify for an expunction. If you are a veteran of one of the branches of the United States military, there's a program that is called Veterans Court. It's part of the pretrial diversion program. You get into the program, case dismissed, complete the program, you can get it expunged from your record. So any branch of the military, if you're a veteran, you can qualify, you may qualify to get into that program as well. Now, this court has a program, and I say this court, County Court at Law Number 2, have a program that is called the CSI programs. Program I started 2017. The program is designed to make Jefferson County, well, CSI stands for Community Safety Initiative. The program is designed to make Jefferson County a safer place. And the way the program works is we have partnerships with agencies in our community. We have a partnership with Spindletop, MHMR. They have a mental health program and a drug and alcohol program that's called ATAR. We also have a partnership with the Golden Triangle Empowerment Center, who has a partnership with Lamar University. And with that program, it's a job training and a job placement program. And I think Spindletop, Lamar University, they have if you need your GED, you can get into the GED program to get your high school equivalency diploma. Now, the partnership that we have with Spindletop, we have individuals in court from Spindletop, mental health officers, counselors. They can do a private interview, develop a treatment plan, assessment, and the treatment plan can either be outpatient or inpatient treatment. With ATAR, the program that they have an ATAR program for youth, 21 years old or younger. That program is a drug treatment and drug and alcohol treatment program. And the ATAR stands for Addiction Treatment and Recovery Program. That's what it means. Now, if you are above 21 years old, then we have, we can send you to what is called OZAR, the local mental health agency. And OZAR as well as ATAR, they can do an interview, a screening, and it could be a treatment plan, either outpatient or inpatient as well. Now, with the program that we have with the Golden Triangle Empowerment Center that has the program with Lamar University, which is CICE, which stands for Center for Innovation, Commercialization, and Entrepreneurship. It is a job training program in the hotel industry, the shipping industry, or the chemical industry. Once you get trained in one of those areas that you select, then it is also a job placement program. They will assist you at getting a job in the area that you are trained in. All of those programs that I just spoke of does not cost you anything. They are free. Only thing you would have to do is have a desire to be in the program. And I tell people this all the time. When you come to county court at law number 2, we don't have court as usual, we have unusual court. And it's not because we're different, it's because that we are trying to make a difference in the lives of the individuals that come before the court, and we're trying to make a difference in Jefferson County by making Jefferson County a safer place for us to live, work, go to school, raise our children, raise our family. And the way we do that is by producing productive people. And if we produce productive people, then productive people, for the most part, do not commit crimes. And the other thing about County Court at Law number 2, we do not just arrest the problem, we address the problem. And so if we address those problems that I just spoke of, then we can make a difference in the community in which we live, okay? Now, we have, I mentioned earlier that we have individuals who are here in court from Spindletop. We have Deputy Hinton, who is going to speak to you this morning. He's going to tell you something about the Spindletop program, and we ask that you please be very attentive. And at this time, I will present to you Deputy Hinton.
Thank you, Your Honor. Good morning. My name is Steve Hinton. I am a mental health deputy licensed by the state of Texas. I work for the Jefferson County Sheriff's Office. What happened was there's a program that the judge instituted, which was the Community Safety Initiative, combined forces with the Court Liaison Program, which brought us together. And we're here with a representative of Spindletop, Mrs. Lisa. She is a qualified mental health professional. She's been there for many years, probably one of the most qualified that Spindletop has. And we work together because we learned that some people that go in and out of the court system, in and out of the jail, sometimes have underlying issues. And as the judge says, we want to address those issues because we can fix those, and we can sometimes fix some of the other events, such as appearing in court as well as going in and out of jail. So sometimes they're mental health issues, sometimes they're substance use disorders. We want to address all of those. If you want to have a private session with Miss Lisa, you can do that today. When the judge proceeding continues, I will be going through and talking with all of y'all. And if y'all want to have a private session with her, she'll take you in the back. We'll have that private meeting and we can walk through this. This is all HIPAA regulated, which means it doesn't go outside here, our knowledge of what's going on here, but we want as much information as we can from you so we can best determine how to help you navigate the mental health system. Does anybody have any questions? Good. Thank you, Your Honor.
Okay, thank you, Deputy Hinton. So at this time, ladies and gentlemen, we're gonna have someone to come by and pick up the forms that you signed. If you haven't completed them, just take your time right now and complete those forms. And then once you have completed filling out those forms, we're gonna have someone to come by and pick those forms up. And then once we go through the forms, then we'll put you into one of 3 categories, and then we'll proceed from there. So at this time, the court will be in recess